This person's comment is in relation to a post I did about pretrial conferences, which, for those of you who don't know, are conferences that a court has before a trial in an effort to try to settle a case or settle an interim issue. The lawyers make their pitch, or pro se self-represented people make their points. Usually there's a memorandum explaining the position of each person or each party, and that's in writing ahead of time. The judge reviews, sometimes some documentation like financial affidavits, but it's a brief thing. It's like typically maybe half an hour. So this person says, why do we have a pretrial conference when there weren't all the facts of our case before a judge? Just my ex spouting his narrative and flat out lying about the facts of the case. Okay, that's you saying that. A pretrial conference is not a trial. It is a pretrial conference. It's just an effort to try to settle. By the way, if you don't want to go to a pretrial conference, a lot of judges won't force you to. Or if you do go to, if the judge does force you to go to the pretrial conference in an effort to settle the case, you don't have to accept the judge's recommendations. If you don't agree with what the other person says, have a trial. That's what it's about. That's what our system allows. A pretrial is a device to try to get people to settle. The court listens to the lawyers and says, hey guys, if the evidence comes in this way, then I'm going to probably rule thus and so, which helps give people guidance on how the judge will come out on the issues. It might not help though. If, like, to use a car accident analogy, if one person says the light is red, and the other party says the light is green, you got to have a trial because the judge has to listen to the testimony of the witnesses and decide who's telling the truth. Or look at exhibits. Let's say one person says that their business is worth $1 million and the other person says it's worth 100,000. Well, you're going to need to have expert witnesses testify about what the value of the business is in the divorce case, and the judge is going to have to decide who's right. There's no way to do that in a pretrial. When you're diametrically opposed on issues, a pretrial is not the place to get that resolved. You're going to still have to try the case. So that's how that works, and part of it is understanding what a pretrial conference is and what it is not. It is not a trial. It is not a contested hearing. A judge is not evaluating the truth or falsity of the facts. Thanks for asking the question. Please keep the questions coming. I'm Raiford Palmer, STG Divorce Law, author of the best-selling divorce book, I Just Want This Done, How Smart, Successful People Get Divorced Without Losing Their Kids' Money and Minds. Links in bio. Like, follow, and share for more. Thank you.